Joining us now is lawyer Danielle Robitaille. She has defended individuals and corporations charged with criminal offenses. She is also the managing partner at Henein Hutchison Robitaille. Ms. Robitaille, thank you for joining us.
Hi, Michael. How are you?
I'm good. Now, as you know, these proposals that were announced yesterday, this really is a response to the provinces and territories who have been looking to Ottawa to make it harder for repeat violent offenders to get bail. And already we've heard from a number of provinces. They say they are encouraged by these proposed reforms. What's your assessment of what's been announced?
Well, I can tell you, Michael, that I've been chatting with my colleagues who are in the courts day in and day out, and the overwhelming response of lawyers, criminal lawyers, both Crown and defense, is this is really tinkering around the edges, and it really sends the wrong message to Canadians about what is really wrong and what's really broken about our bail system. So that's really the concern that I'm hearing from criminal lawyers, that really the efforts and the legislative amendments should be directed at what we are seeing on the ground, which is the over-incarceration of Indigenous people, racialized accused. We're seeing that our jails in Ontario, 70% of the population in our jails in Toronto, in Ontario rather, are made up of people who are awaiting their trial. So they're legally presumed innocent, and nonetheless they are incarcerated. And so that's really the concern today on the ground for people who are in the trenches working the courts.
Okay, can we build on that though? Because for the average Canadian, what they are hearing is this call to make sure that repeat violent offenders are not taken in and then released by the courts. How is that not in keeping with, at the same time, protecting Indigenous individuals, racialized individuals who, as you say, are overrepresented in the justice system?
Yeah, so I think it's really important for Canadians to understand that we all have a right to reasonable bail, and it's protected in our Constitution. It's protected under the Charter of Rights and Freedoms. We're also presumed innocent until found guilty after a trial. And so any legislative amendments that are made will be made under that umbrella, under those constitutionally protected rights. And so these reversals of onus are not likely going to change very much in terms of how bails proceed in our system. And I think the concern is that there were a number of really terrible human tragedies that happened recently. And we see this, right? We see governments respond, and there's a little bit of political opportunism here. And we see that on both sides of the aisle, that there is a knee-jerk response for legislative reform that doesn't take into account a system-wide perspective of what's really happening. And so when you respond to isolated cases, you make bad law. And I think that's what we've seen here today. And the message that's being conveyed to the courts, to the justices of the peace and the judges that make these decisions is, we'd like you to hold back more people. And we know, as criminal lawyers, we know that they're already holding people, way more people than they ought to be. People who are presumed innocent, they're legally innocent, they're waiting their trial. And so, I think what we would be looking for, people who work in the system, are investments that would go towards improving outcomes for the marginalized accused and the victims of crime. But those are expensive, they're complicated, they don't make for sexy sound bites, and it's really unfortunate, but we see time and time again that these issues don't get the airtime that they deserve.
You talk about catchy sound bites, and certainly a phrase that we keep hearing over and over again is the current system, if left unchanged, is what some Conservative members of Parliament describe as a catch and release system. What do you say to that?
I do think it's a good soundbite. I think that it's extremely attractive, and it sounds tough and macho when we say things like jail, not bail, but it ignores the constitutional reality. It ignores our founding principles. And what we have decided as a community is that you are presumed innocent until you're proven guilty and that you have a right to reasonable bail. And what we know, and what statisticians and social scientists have been saying for generations now, is that warehousing people for longer and longer periods of time does nothing to keep our communities safe. And so it sounds great, you look tough, you look principled, but it has zero impact on the lived realities of people who are most impacted by crime and violence.
Of the people who are right now being incarcerated, denied bail, how many of those cases prove to be come to a not guilty verdict or an innocent verdict?
Well, that's a great question. It really varies by offense. So you see that certain offenses are a coin toss. There's outcomes in the 50-50 range for those cases that go to trial. But of course, most cases don't proceed to trial. Most cases end in a resolution, normally a guilty plea. And the concern with holding people and not releasing them on bail is that what you do is, and there have been studies that show this, you induce false guilty pleas. You know, the thirst for liberty is much higher than a thirst for justice when you've been sitting in a cell for a long time. And so what we see is that people, when they're detained, they're far more likely to plead guilty to something they didn't do or something for which they had a valid charter defense to argue because they want to get out. And so if these changes result in tougher and barriers to bail, I think what we are going to see, I think the downstream outcome is more likely to be false guilty pleas and more miscarriages of justice, wrongful convictions. That's the concern that we should have as a community when we make these knee-jerk legislative reforms.
Do you think these proposals, these reforms, will stand up to a court challenge?
I think they will. We have seen that reverse onus challenges have failed in the past, and so I think these reforms will pass charter scrutiny. I think the broader concern is, why are we putting our energy and our effort and our time into these sorts of matters? This is not really what is wrong with our system. And it's always a mistake to zero in on a couple sensational, difficult, tragic cases. What is the gold standard and what we ought to be doing is, as I say, take a system-wide perspective, listen to the Crowns, listen to the Defense Council, fund the system, fund the Crowns, fund the legal aid system so that we can have a more efficient system. Maybe put your energy into staffing the courts. Jacques Gallant of the Toronto Star is doing excellent reporting on the fact that we have a courthouse, a new fabulous courthouse in Toronto that does not have staff to run trials. And so let's look at the system and let's fix and repair the real holes instead of trying to win easy political points.
Danielle Robitaille, I really appreciate the time. Thank you for that.
Thanks, Michael.